Hold up, we're 4 seconds in and he's already admitting to stealing from a child's grandfather? Yeah, buckle up. When a defendant starts a hearing with crimes and excuses, judges usually come in swinging.
So do you waive the reading of the indictment?
I do.
State, in cause number ending in 302, are you proceeding on the indictment as presented?
No, Your Honor, we make an oral motion to amend the indictment to remove the defendant's middle name of Guadalupe. Additionally, Your Honor, we'll waive the habitual offender enhancement.
Okay. Elderly or disabled person with intentionally bodily injury. And the cause number ending in 304, you're charged with assault family household with a previous conviction. Both of those charges are third-degree felonies. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. Defense?
Yes.
State?
That's the plea, Your Honor, yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, there be any such motion? Then in the cause number ending in 302, how do you plea? In the cause number ending in 304, how do you plea?
No contest, sir.
State any evidence.
Yes, Your Honor, with regard to both cases, they will offer into evidence case exhibit 1 with all attachments. Okay.
All right, state, and have you had a chance to speak with the complainants?
We have, she was unable to make it today because she would like to give an impact statement, and she was asking if Your Honor would consider delaying sentence to maybe Monday so she can come in.
All right.
Thank you.
And let me ask you, is she able to Zoom in?
I can call and see if she can right now, actually.
Great, thank you.
Thank you.
Just for the record, I'm supposed to be starting.
Anytime a narrator says this is the worst case, and they've already covered dozens, you know it's about to get messy. And the fact that it involves a special needs child, courts treat those cases like emotional landmines.
Trial Monday in 175th, so I'd rather not.
In each cause number, the court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
I would like to proceed today, Your Honor. Actually, I spoke to the DA, that gentleman, but earlier, she's not here now. She said that she was not seeking to have the picture and bank statement, that she told the mother that it wasn't going to happen. So that's what she told me. I thought I was kind of surprised. But I'd like to go forward today.
All right, anything you wish to say? So why did you do this?
The kid was doing anonymous stupid things, and he tried to work on me.
I'm sorry, you said the kid was doing what?
Anonymous stupid things.
What does that mean, anonymous stupid things?
Touching his knees, watching him and his mom have stole a phone from his godfather.
Oh, so then why are you not closing your door?
Because there wasn't a door.
All right, so then that sounds like a you problem. And this child is special needs. So what have you done to this child other than put fear into this child?
I just spoke to him about.
Quick legal moment. When the state waives a habitual offender enhancement, that's basically sparing the defendant from decades more prison time. But don't mistake that for mercy. It usually means the evidence is strong enough without it.
You're complaining about him and you were not even employed. So how are you making money?
A job for her.
I'm sorry, what?
Helping her with the job she was doing. She's a home care provider.
Oh my gosh. Just have all these random people being home health care providers. So basically you were doing nothing. You decided to get in a relationship with someone who has a special needs child. You're living off of her. You're doing nothing. And the fact that you have zero patience with this child, and for them to put in the police report that you're a stepfather, I can't even believe they would use those terms with you. You don't have any patience, and somebody is letting you and her be a home health care provider. And how old are you?
I'm 43.
So you're doing anonymous things like not having employment. This is what the court will do.
Here's where defendants love to self-destruct. When a judge says, "Why did you do this?" you're supposed to show remorse. Instead, he blames the child. This is the moment the judge mentally locks in the maximum sentence.
And cause number 2025 CR 005304. The court is going to find you guilty. The court will sentence you to 8 years in the prison. There's a $1,500 fine. Credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Carlos Coronado or Andrea Graham. There's to be no residing in any household with minors, and there's to be no contact with minors. This will run concurrently with 2025 CR 005302. And cause number 2025 CR 005302. Court is finding you guilty. Court will sentence you to 8 years in the prison. Give you credit for any time served. There's a $1,500 fine. This will run concurrent with 2025 CR 005304. There's to be no contact with Carlos Coronado, Andrea Graham. There's an affirmative finding of family violence. There's to be no residing in households with minors and no contact with minors.
Listen to the judge's tone shift. This is no longer a sentencing. This is character demolition. When a judge starts listing your life choices like bullet points on a PowerPoint titled, "Why You're Going to Prison," it's over.
In each of the cause numbers, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Sure.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, because they're an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right. So we're off the record. Here's the reason. This is why I'm doing no contact and no residing in households with children. You know why I'm doing that? Because there is somebody who had a special needs child, decided that you were a good catch, and guess what? You don't have employment, you have no means of supporting yourself, and she's probably receiving funds for that child because that child is special needs, and y'all just living off that child. And Child Protective Service should be called because she shouldn't have custody of that child, because she's bringing somebody in her household who has prior convictions for affirmative family violence, and she thought you were a great catch. Somebody who has no job, previous convictions, and letting them live in the home, live off a special needs child. So that is why. So that will not be happening. Do you understand?
Sure.
Oh, and you're dismissing this case?
Yes, sir.
All right, they're dismissing the missing witness. Thank you.
Thank you.
And there it is, the gavel moment. 8 years, back-to-back charges. No contact with minors ever again. Judges go hardest when a special needs child is involved because courts consider them among the most vulnerable victims.